is time now for Night Court. Baseball spring training is in full swing, and now a court in California is jeopardizing a cherished legal protection in America's pastime. The court did not defer to the so-called baseball rule, where fans are expected to understand that they assume the risk of injury if they get hit by a foul ball. This rule is challenged over and over. For example, there's this New York case a few years ago where a fan was seriously injured in Yankee Stadium.
I never saw the pitch. I never saw the swing. I never saw the ball flying through the air, but it just bang hit me right in the side of the head.
So is the California court striking out or hitting a home run by telling teams that they could be liable for foul ball injuries? Well, tonight's Legal Eagles, we've got criminal defense attorneys Alex Little and David Bruno. All right, let me pop up Exhibit A. It's from a 1997 state appellate court ruling, and it reads, if such foul balls were to be eliminated, it would be impossible to play the game. Thus, foul balls represent an inherent risk to spectators attending baseball games. David, take it away.
There it is. That's the general rule. That's the baseball rule. And you know what? It makes sense, because when you buy a ticket, you have to assume that risk, that when you go into that venue, this is a possibility. And if everybody looks at their ticket, it flips it over, that's exactly what it says. But, you know, there are limitations to this rule. And in fact, let's say the stadium doesn't put a net behind home plate. I mean, that would be liable. They would be liable for something like that. So it's not every single injury in a stadium. It's the ones that they did not protect. And when you walk into that stadium, you have to be ready for those balls.
They make me nervous. I'll tell you what, every time I go to a baseball game, I'm thinking about it. All right, time for Exhibit B. It's a William and Mary Law Review, and it says, quote, courts continue to rely on a 100-year-old legal doctrine when determining whether to hold teams liable for spectator injuries resulting from errant balls or bats leaving the field of play. Although the baseball rule may have been justified at the time it was first established, its subsequent legal development, as well as recent changes in both the law of torts and the game of professional baseball itself, have undermined courts' continued reliance on this antiquated doctrine. Alex?
Yeah, that's it. I mean, look, the courts got lazy. They kind of relied on this rule from 100 years ago when you played baseball in this open-air stadium, and there wasn't much that the owners could do to protect the folks in the stands. But these days, we have this thing called netting. It doesn't just have to go behind the home plate. It can go on the sides. It can protect people that, you know, you can try to dodge a ball if maybe you're an able-bodied adult, but if you're a child or an elderly individual who wants to watch the game, it's not so easy. And at that point, the owners have an obligation to protect you, and that's kind of what these courts are saying now in California.
All right, I've got to quickly get to our next case. It involves a former Pennsylvania mail carrier who is accusing the U.S. Postal Service of violating his rights by requiring him to work on Sundays. David, make your case.
Yeah, I'm for the employee here. So Title VII of the Civil Rights Act requires employers to accommodate. They can't discriminate based on religion, and they have to accommodate. For this individual, he believes that Sunday is a holy day, a rest day. And when he makes the employer aware of that, well, then they have to do everything in their power to make sure that he doesn't work. Hey, this is 7-day week, so if he doesn't work on Sunday, get someone else to do it. And they failed to do it. In fact, not only did they fail to do it, but they suspended him and ultimately terminated him for not showing up on Sunday.
David, I got to jump in. Alex, you've got 30 seconds.
Yeah, well, the real boogeyman here is Amazon, because this all started because Amazon convinced the Postal Service to start delivering on Sundays. So a guy who was able to not work on Sundays now had to. Postal Service couldn't find somebody else to do it. There are only 3 rural mail carriers in his region. And so at that point, the law says, no, if you can't do the job that you were hired to do, they can fire you. And that's what happened here.
All right, gentlemen, thank you so much for being our Legal Eagles on this Friday evening. Thanks for staying up late for us, and for all of you at home.